Hello everyone, my name is Catherine Lofton. In this presentation, I will briefly overview competence to refuse an insanity defense and other mental state defense and discuss a related case that addresses this important topic. What is the insanity defense or other state defenses? The insanity defense and other mental state defenses highlight the complexity of the legal system in addressing crimes committed by individuals suffering from mental health issues. They aim to ensure that individuals are accountable to the extent that they can understand their actions and the consequences of those actions, thereby promoting a fair legal process that considers mental health in criminal responsibility. The insanity defense is a legal argument used in criminal cases to assert that a defendant should not be held criminally responsible for their actions due to the severe mental illness or defect at the time of the offense. This defense is based on the principle that the individual who cannot understand the nature of their actions and distinguish between the right and wrong should not be punished like those who have full control over their actions. Mental illness, the defense must demonstrate that they had a mental illness or disorder at the time of the crime. This could include conditions such as schizophrenia, bipolar disorder, or other severe depressions. Impact on understanding. The defendant must show that their mental illness impaired their ability to understand the nature of their actions or prevented them from recognizing that the actions were very wrong. Other mental state defenses. Diminished capacity. This defense argues that a defendant had a mental disorder that previously prevented them from fully understanding their actions or forming the intent necessary to be guilty of a particular crime. Unlike the insanity defense, diminished capacity does not absolve the defendant of responsibility but may reduce the charges or penalties. Automatism. This defense, when successfully argued, can lead to a significant legal outcome, a complete acquittal. And this invoked when a defendant claims they were unaware of their actions due to the medical condition, such as sleepwalking or certain types of seizures. Temporary insanity. This defense suggests that the defendant was insane at the time of the crime but regained sanity afterwards. This emphasis here is on the temporary nature of the mental disturbance. Compulsions or duress. While not strictly a mental state defense, it asserts that the defendant was forced to commit the crime under a threat of immediate harm, thus impacting their mental state during the act. Why refuse an insanity defense? The competence to refuse an insanity defense refers to a defendant's ability to understand and make informed decisions about whether to assert this legal argument in their case. This concept is important because it ensures that individuals can participate in their defense and make choices that affect the outcome of their trial. Stigma. Even though mental health awareness has become more common in recent years, there is still a stigma around it. Some people do not want to admit guilt. Some may refuse this defense because accepting it means they would have to be admitting to guilt, even if an insanity defense may benefit them more than being found guilty. They'd rather do jail time than hospital confinement. Some defendants may refuse this defense because they believe they will have more freedom in jail than a mental hospital. Some just disagree with the defense. Some may simply refuse because they do not think of themselves as mentally unhealthy. Although they may visibly suffer from mental health disorders, they do not believe they do. Other are views of political and religious acts. Two pivotal Supreme Court decisions have significantly influenced the laws governing a defendant's ability to waive an insanity defense. The Wallen v. United States, the Supreme Court vested judges with the power to impose an insanity defense when they deem it viable. This ruling was a crucial step to preventing individuals from being convicted solely based on diminished mental capacity without a proper defense. The court's rationale was clear. A defendant in such a compromised moral state during a crime could not be held legally responsible for their actions in the court of law. On the other hand, the Frederick and United States ruling mandated courts to respect a defendant's decision to invoke an insanity defense, as long as the defendant was not found incompetent. This decision underscores the principle that defendants must bear the consequences of their choices, whether they choose to assert or waive the insanity defense. Ultimately, the court emphasized that the defendant's interest should be prioritized over the judicial system's desire for perceived justice, a key element highlighted in the Wallem case. While the Frederick Standard has gained broader acceptance in many jurisdictions, some courts still adhere to the precedent set by Wallem. The difference between these two standards are significant, particularly concerning the evaluation process used to determine a defendant's competency. Under the Frederick Standard, courts focus solely on the defendant's present ability to make an informed decision about rejecting the insanity defense without delving into their mental state at the time the crime was committed. Andrea Yates admitted to drowning her 5 children in their home in 2001. Miss Yates faced capital murder charges for her crime, with a potential death penalty. During jury selection, all jurors accepted the death penalty, creating a death-qualified jury. Yates pled not guilty by reason of insanity, a rarely successful defense. While both sides acknowledged her mental health issues, with prior hospitalizations and a diagnosis of severe depression, the defense argued her insanity. The prosecution contended she was aware of her actions when she drowned her children. The McKnight Rule and the irresistible impulse test were applied to assess her mental state. Ultimately, she was found guilty and sentenced to life in prison. However, she was granted a mistrial. Park Diaz, a former psychiatrist and an expert witness in the Andrea Yates trial, falsely claimed that a Law and Order episode depicted a mother drowning her children and then pleading insanity. This assertion was proven incorrect, as no such episode existed before the trial. The relevant episode was released only after Yates' initial verdict. Realizing Diaz's error in her second trial, Yates explained that she was believed drowning her children would save them from Satan and guarantee their passage to heaven. More evidence of her mental health issues was presented, including her history of psychosis and psychotic breaks, and a diagnosis of severe major depressive disorder. Yates pled insanity, and the jury found her guilty by reason of insanity. Although she has the option for her case to be reviewed, she has chosen to waive the right, possibly remaining in psychiatric hospitals for life. My questions for the class: should the standard for assessing competence to stand trial and refusal of mental state defense be uniformed across jurisdictions, or should they vary based on local legal traditions and mental health resources? Why? How might a defendant and intellect disability create unique challenges in the courtroom that legal professionals and mental health assessors must know?